where there may not be a lot of evidence or there's not many documents. There are cases that are very low in value, but they can require just as much time and effort as preparing a case that's worth millions of dollars. So these are important considerations for a client to think of before they embark on the process, and it really does help to give them pause to consider whether this is the way forward for them. A further reason is the complexity. It may be that you're a very competent solicitor and can run certain matters that you're accustomed to receiving. But then again, something might involve various areas of law, some questions, or including complicated facts. This is another good reason. Frequently with small firms, they might lack the resources. It may be that someone goes on maternity leave, for instance, or that there is only a sole practitioner operating, or that the skills, the necessary expertise is missing. And this is a way in which junior barristers often receive a brief, and it also is a mechanism by which smaller firms can actually compete with larger firms if they secure the engagement of the appropriate counsel.
And I suppose as well, it depends, doesn't it, on the stage that the proceedings are at. But generally speaking, where there's expert evidence at play, for example, or perhaps some very complicated oral evidence that's going to be led at trial, it's important, I think, for barristers to get involved at that stage of the proceedings in order to perhaps help draft witness statements or affidavits, especially where at the moment there seems to be this conflict between the federal court and the Supreme Court with respect to direct speech, for example, and
yes,
that sort of consideration. But have you had any sort of direct experience of being involved at that stage? Or?
Yes, I have been in cases which are quite large and cases that are worth quite a lot of money. And unfortunately, in patent cases, it might be that solicitors have prepared evidence, often with experts, without really counsel's guidance or without listening to it. And unfortunately, it can be quite difficult. And sometimes I think experts are paid, and even with the best endeavours, they're quite intelligent people. They can often work out what is required of them or what their legal team would want. So it's really crucial. The most important thing with expert evidence and any evidence is that it is that witness's evidence, because what happens is it comes out in court eventually, and you really don't want that discrepancy. So I think having counsel involved in that, especially giving all the requirements, for instance, with witness experts, you need there's practice and procedural requirements, there's the Evidence Act, even securing an expert, working out who it should be and posing questions, settling that. It is very helpful to have counsel involved at an early stage, that you're not in this invidious position where your own evidence is actually operating against your case. Yeah,
I completely agree with you. And I think from my own experience, the most effective expert evidence that I've seen being given in court is as a result of many months of preparation, and getting barristers in, especially those who are going to be presenting the case at trial, in at such an early stage as to settle the questions to experts, for example, because sometimes, I mean, it depends on the circumstances, I suppose. If you have a large firm like Mallison's or Freehills, etc., they have the resources there that they can call upon. But smaller firms, perhaps less so. And sometimes when I'm seeing questions posed to experts by small firms, I look at them and think, I wouldn't be approaching it this way. I should be doing it a different way. And then when you usually get everyone together, including the expert, to have an informal conversation in the first instance, you can actually direct everyone's attention to certain specific questions, which then has this nice flow-on effect. It's like the feng shui, as it were, of litigation heading towards trial, and then you only reap the benefits of getting a barrister in at that particular stage.
It's true, and there's also almost an initial phase often, which is to use the expert to understand what it is that's been spoken about. They're there, after all, to inform the court. And so going through those processes, and even bigger firms actually, because of that relationship, the direct relationship between the client and the solicitor, it can help to have someone who's a little more removed to look at it to get the best results, I think, as well.
So generally speaking, that's why we tend to get involved at an early stage. Let's talk about when specifically to brief, and the considerations of why people would like to get barristers, or why they should get barristers involved early, just for the avoidance of doubt. The night before a hearing is just too late.
Or the morning.
Or the morning. Yes, that's very true. I've had that before now. I know this is probably going to descend into a war story, but I do have a distinct memory. I sometimes still lose sleep over the fact of having to go to court, that having been briefed the morning of a hearing and reading the brief between traffic lights on the way to court. I still, many years later, lose sleep over that. When specifically do you think is the ideal time to get someone involved in the bar?
Well, it might be that you've just been served with a statement of claim, okay, an originating process of some sort, and that's not a bad time even to say this is what we've been served with, get some instructions, prepare your brief, and then you can work out how best to prepare a defence and whether you need to request particulars or any documents, for instance, that are mentioned in that document. That's one thing. If you've got a client who's considering commencing proceedings, again, I think earlier is better. Once you've considered it and prepared your chronologies and your observations, I think earlier always is better. And it depends on the circumstances. It may be that, that it's an appeal. So as soon as you want to appeal, if it's not the same team, if it is the same team, you need to get all of those documents, all the documents from below, and start preparing appeal books and brief someone.
And people might be amazed that it actually takes a bit of time to prepare.
Yes.
And so it's nice to have, even speaking as someone who's now unfortunately senior in the profession, that it's nice to have a relatively long run up to a hearing, and not to feel rushed, because that sometimes does manifest itself in court, even though we do our best to suppress that side of matters, but it can sometimes look a bit rushed in court in the presentation. So I agree. The earlier the better. And also, if the proceedings are at an early stage as well, it's necessary for barristers to do conflict checks, especially in specialist areas where it's not unusual that barristers have a very specific knowledge of maybe the defendant bar or a plaintiff bar, and occasionally there can be some conflicts which have to be navigated quite carefully. That can be done, I suppose, though, by speaking to the clerks such as ours here, Jackie, or clerks in other chambers. But that's an important consideration as well. I think.
And matters can arise as well. So if you're thrown into it at the last minute, there may be something that you haven't had time to notice about a witness or something in the case that's relevant to whether you should be appearing in it. So it's always nice to have some comfort and have had time to percolate through the ideas, because things do occur to us. You realise things about a case, or a better way to approach it, or that you don't want to use a witness at all, which is another aspect, because if you can rely on a document and you're given that at the beginning, that makes life easier, because we don't know how evidence will fall out until it falls out in court. And often issues developed, and it's not until during a trial that we really work out what is crucial sometimes.
Yeah. And even on an appeal, to your point, I think it's important to have a team effort in the preparation as well. And that actually requires a long lead-in period. And one of the most effective appellate strategies that I've seen was when senior counsel got junior counsel and a relatively large legal team together, and went through the whole hearing in terms of what was going to be said. And it was so important as it transpired, because the points which were being picked up by senior partners, even junior lawyers and junior counsel, really aided in the presentation. So when it came to the actual hearing, it was a very smooth hearing as a result, and we anticipated a lot of the questions, which really helped senior counsel in the preparation. Yeah. But that was weeks in advance of the hearing, even perhaps a month and a half away from the hearing. So it's really important, I think, to get people in at an early stage.
And it's sort of interesting too. I mean, there's not much point really in having a team unless people contribute to it. And everyone has a different perspective. People are going to have a different take from their background and experience and the way that they see the world and what they know of the world. So all of those, whether they're ultimately taken into account by senior counsel, for instance, when they present a case, it all helps factor in to work out what to do. I was just in a large patent hearing last year, and it was really, there was a witness, and I looked at this witness and we talked about it, and I thought, no, we should be really nice to this man. He came across well and honest, and I thought he's going to agree with us. And he did. He pretty much had ended up preparing a 14-page document with all of the evidence that he gave us, and that was in cross-examination. So you can also get your evidence from the other side, not just what they write, but what happens in court. So it's really worth what people's take on people is important, and observing in court and being aware of what's actually happening in front of you, what the judge wants to know as well.
Yeah.
What's actually occurring, and responding to that is of great benefit, and everyone's take on that, because someone's looking at the expert witness and someone else is looking at the judge and someone's looking at the solicitors, and you learn a lot.
Right, no, I completely agree. So we've looked at why to brief and when to brief briefly on those topics. Let's move to the more substantive aspect of this, which is how to brief a barrister. What's the starting point? I mean, I think we have to assume that anyone who's online or in the room is particularly junior, and perhaps they have no idea how to brief a barrister. So forgive us if we're actually dumbing this down for everyone. But if that's the case, I mean, what's the starting point?
I personally think the starting point is understanding or comprehending what's going on. And something that really aids in that is to get some documents that are objective and you can understand what's happening, and also a chronology. So to start a chronology of what's relevant so you can see what's occurring. And once you have some documents in chronological order and a chronology, then the course of events starts to become clear, and you can build on that. For instance, you can conference the client, form some impressions, find out where it's up to. It might be that you've just been, again, served with a statement of claim. It might be that you're considering a case. It could be any number of circumstances. There might be a court deadline. You know, your firm might receive at the last minute a brief, probably because the client didn't pay. You might receive a brief at the last moment, and then you're trying to work out what to do. So there are actually quite useful resources on the New South Wales Bar website. There's a little banner using barristers and then briefing barristers, and there's actually a toolkit. So there are examples of observations which go through what you could or should include, and an index which would go through what you should include again in your brief, and a checklist. So the Law Society website, they have a Working with Barristers handbook, which is some 44 pages long and covers a lot of topics. So you can just type in, I just typed in Law Society and Working with Barristers, and that's what popped up. So they're really useful tools, general tools. And there are some barristers that have specific manuals actually about how they want to be briefed and what should be included. And I found that interesting, looking at that, preparing for this.
I think that I'm aware of a few barristers around Sydney in particular that have a specific way of working, and they've published a protocol as to how to brief them. I don't think a lot of people in these chambers take that approach, but perhaps they do informally, and a lot of barristers might have an informal approach to it. But upon analysis of those documents online, though, some of it's actually pretty useful stuff. But in terms of briefing someone from the very outset, do you have a preference into whether it's e-briefing or whether it's like me? I'm a little bit antiquated. I like having tangible things in front of me and turning pages and highlighting and things like that.
Yes.
Or maybe a hybrid of both. Do you have a preference?
Yes, I do. My preference, if it's late or urgent, is to be given a paper copy, especially if I've got a few of those sorts of matters that I can look at them quickly and deal with it. However, there are some matters that are just, especially things in the federal court, they're just large, and there's going to be a court book, an e-court book. And it might be that, like, for instance, the patent case I had, I'm responsible mainly for one patent, so I've got to have that information. But then there's other patents that aren't my main job, but then I might be given work and I can work out what is there on the electronic brief and find out what I need to do for whatever task I've been given. So people vary, but personally, I think both is good. You can search electronic documents as well and do different things. But I like having a paper copy, especially in court, so I can find things and write things on it. You can still write on the computer, but so I can find things. And documents I've got to look at again and again, like the patent I'm working on. You've got to read it from this perspective and that perspective, and I want a paper copy of it. So people vary. I think sometimes though you can't avoid an electronic brief. The difficulty is though having, and some judges have mentioned, haven't they, that so some cases where the judge will actually say, if you don't take me to a document, I'm not going to consider it, because you know they're not impressed with being flooded by all of these peripheral sort of.
Well, especially in those larger cases as well. But do you like being emailed briefed directly, or I mean, in my case, I sometimes get emails from those that I haven't worked with before, and they'll just say, "See attached brief."
Yeah.
In which case, there's been no conflict check, there's been no cost agreement being sent or anything like that. So what I usually do is I refer that email to my clerk or my EA to liaise with the law firm or someone, perhaps if they've come to me directly, to go through that process first. Do you have a similar approach?
Yes, I do. So when I get things like that, then I'll have an initial look at it and I will set out a cost agreement, cost disclosure, and discuss that. And sometimes, depending on the nature of the case or whether I'm familiar with the law firm or not, or I've worked with them, sometimes I'll ask for fees on trust as well, which can be helpful if you're clearly looking at someone who isn't very good with their money.
Yeah. And so when all of that has taken place and the brief finally comes in, do you have a preference in terms of the way the documents are structured in the brief? Because a lot of law firms tend to take a very different approach to this.
What I actually do personally is I just deconstruct them and put them together how it suits me.
It's very time consuming doing that. I've actually done it quite recently, and I've had to deconstruct the brief as well and reorder things and ask for further documents. And that actually is counterproductive in many respects, because it's ultimately the client is going to be responsible for the cost of all of that.
Yes.
And so a really efficient brief actually goes a long way.
It does, especially if key documents, like I said before, are arranged chronologically. You know, you have a full set of pleadings, and also the older pleadings, but somewhere else, that you can see what orders have been made in court and where it's up to. And that's another thing, that's another issue too, is to make sure that, you know, that we know if there's some sort of deadline, especially a court deadline, so that when we first get the brief, that's clear and we can initially look at it through that lens to prepare for whatever the deadline is, whether it's preparation of evidence or appearing in court or what have you.
So the first thing that you like to see when you open up a brief, I don't know whether you like
it's a pink ribbon. I like to see a pink ribbon,
right?
but you know.
Who doesn't like a pink ribbon? But I mean, for me, as aside from a pink ribbon, the first thing I like to see is usually the observations, and then perhaps followed very swiftly behind by an index, and we'll come on to all the other bits and pieces in a minute. But let's talk about the observations, because any junior lawyer who is tasked with having to draft this, and let's face it, it's going to be a junior lawyer who's going to have to do it. It's not going to be the partner there sort of typing it out. So, well, you never know, in fairness, but let's assume it's a junior lawyer. Sometimes I find I'm given an observations and it's like reading War and Peace. I much prefer seeing a very succinct document, usually about a page and a half, 2 pages tops. I don't know if you take a different approach.
No, I do as well. I want to see a deadline really clearly. I'd like to see what your view is, what the client wants. But I actually sometimes, if I know that there's no major deadline, I actually prefer to consider the brief and form an opinion myself, and then look at what the solicitor thinks, because then I find that interesting, compare that, see if they've got the same sort of impression as I do. or if there's something different. So I prefer to actually read the observations last, if there's time.
Right. So I suppose, I mean, that's one of the reasons why it's important to speak to the clerk if people have never worked with you before, or worked with any other barrister before, just to get an idea as to how that barrister would like to work or operate. And it may be that sort of in your brief, the observations would come towards the end of it.
It's okay. I could live.
Yeah, but perhaps that might be an idea as to why people should phone ahead first. But in the observations, for me, I like having, like you say, whether or not there's a deadline. I like to know the facts of the case, as very briefly stated. I don't need to read the entirety of the case, just the headlines as to what I'm looking at, followed by the questions that I've got to answer, whether it's an advice on prospects or whether it's an advice to a peer. But the kinds of things that I'm likely to need to advise on urgently, and if I've got a bit more time, the deadline. And then, as you say, I'm the same as you. I'd like to see what the solicitor's opinion is on things first, and then get stuck into the nitty gritty, as it were, of the facts. But I can do that on my own time. I don't necessarily need to see it in the observations.
Yeah, and again, I think it's important. You're working on the case, and you will form impressions, and you've probably met the client or maybe a witness, and we haven't yet. So, and there'll be areas of doubt that you have, and you're seeking assistance, so you can specify those. I'm not sure about this, I'm wondering about that. Just saying all of those things can assist us to help you.
Yeah. And so when we've read the observations, and it's a pithy document, and we understand the deadlines and we understand the questions that we've got to answer, the next document I like seeing is the index. I suppose, which is, it can be controversial, in index, apparently. Do you have a certain outlook on what the index should look like?
Well, I think like you've said, if it's simple and clean and I can look at it and see at a glance pretty easily what is there, and maybe, also what's not there, that helps. It might be about an agreement. I want to see the agreement, of course. Any sort of crucial document like a contract or a guarantee or something, include it, or it might be some financial information or an ASIC search. So I like to just be able to look through and see what is there reasonably simply, and then to see where the pleadings are up to. I mean, one of the first things I like to look at is the pleadings, because I will write out a list of what's an issue, so that I can then start even right there thinking of straight away, do we have the evidence here? What do we need?
I agree again, but I was, just before starting this seminar, I thought I'd jot down a few things that I like to see, and I agree with you. I think the first thing is I'd like to see the pleadings, and a complete set of the pleadings as well, so I can track through what's been alleged before and what's been agreed and what's not. And then perhaps if there's a chronology or a dramatis personae. I know a lot of judges in the federal court these days tend to like having dramatis personae, especially if it's a big case and there's lots of personalities involved. Whether there's been perhaps any submissions that have been filed, or perhaps some sort of written advice which has been given to the clients from the firm of solicitors, or perhaps former counsel. And then the other things I'd like to see, I suppose, are aside from proofs of evidence, which we'll come on to. I'd like to see issues for trial, and any admissions that have been made. And then I think this is I hark back to my UK days for this next one, and this is probably a bit more specific to me. But I like to see all the orders and applications that have been made in the case, and I want them all in one place. And so even if a law firm hasn't given me that information, usually I'm either on the federal court website or the New South Wales Supreme Court equivalent, trying to print out all the orders, so I know exactly what's happened. And I don't think that's a waste of time knowing how it's all progressed, because you get a sense from the usually a docket judge, for example, in the federal court, how he or she is as case managed the case to date. And then otherwise, I was thinking sort of discovered documents, I suppose, would be another reasonable request.
Yes.
To having a brief if it's leading up to a trial or something. But that's the way I tend to order it. Would you sort of do something similarly, or?
Yes, no, I think all of that is really important. It's also, especially with the docket judge in the federal court, you've got the same judge, so you can really form an impression about how the case has been run, about what kind of, how they might be seeing it, by looking at those documents too. So, you might be asked brief to do something and you're going to think, oh, the judge is not going to like this because we've already ran similar applications or asked for similar things. There was a negative attitude towards it. So you do need to understand that procedural history, especially when it's in front of the same person.
And then chronologies. Chronologies are really useful, I think, in, and personally, I sometimes draft my own chronologies, even if I get one from the solicitor, because it's the way I tend to work. I like to get something into my thick head. Do you have a way in which you communicate that to solicitors, or perhaps you have a certain way in which the chronology should be compiled to your mind? Or?
Yes, well, I mean, I guess personally I prepare my own chronology because that allows me to understand what's happened and what I think I need to ask for. But if a solicitor prepares one, that's very helpful too, because there might be, I can look through that and get some key dates or work some things out. So I actually think that, personally, I think the chronology is a really good thing for each person to do for themselves, for their own comprehension. And if you've done one, by all means share it. Some barristers will use your chronology, some will refer to it, and some will not rely a lot on it, make their own. You can also make chronologies, for specific purposes. It might be that if you've got an application, you have to know what's happened procedurally, and you can do that. Or in the substantive matter, there might be issues, but you might want to hone in on one issue, for instance, and you might have a sort of separate chronology of that particular discrete issue. But basically, you want to have 3 columns at least. So you need to have the date, and this can actually include timing sometimes, because if you look at correspondence, emails and texts and so forth, you'd be amazed what you can realise, like when you actually order things and you go, right, it seems obvious this happened for this reason or that reason. It conveys a lot of information, which helps you with strategy. But anyway, so time, event, in a simple way so that you can see what's happening, and then the source, because later on you think, I've got that fact, but where from? You can even, in some cases, if it's simple, like hyperlink that, so you can just press on the document. I usually have a 4th column where I put comments, basically, so I might, want to follow up on something or seek some instructions. There might be a legal issue or some doubt I have, or just some comment. So I'll also have like a section. I usually get rid of that as I develop it, but that's how I normally.
What about the whether or not they should be more comprehensive or not? I have a tendency, I don't know about you, but I have a tendency to prefer a less comprehensive chronology, and I find sometimes, especially in commercial matters, where junior lawyers have been tasked with a chronology, they've probably just worked out where the computer room is, they've probably just worked out where the photocopier is, and then they've just been told, please do a chronology. And understandably, they, perhaps out of anxiety, have created a chronology which records
every document
and down to the last time that the client had lunch. And it's probably a little bit OTT.
Yes.
And I then just stop reading the document, because it's like, well, I might as well just do my own. Whereas if it's just, the salient facts, when the statement of claim was filed, when the defence was filed, when the matter was last in court, what have we got coming up? The big ticket items, at least that's sort of a really good way of just getting information inside your head really quickly. And you can be quite nimble then going through the rest of the brief.
Yes, I think it can be quite overwhelming as a junior solicitor, especially in a big matter. There's millions of documents and chronology. So understanding that case, and you're not receiving necessarily all the information because the partner might have that. So it can be difficult to understand it. The pleading's are a good place to start, though, to see what the issues are. And you can just think about it, try to think about it from a logical perspective about, what do I need to prove? What's happening here? What's really central to that? And include those things. And don't be afraid if it's briefer. It's probably good.
And I don't know whether there's the functionality these days as well. Perhaps I think there is, where you can perhaps do a more comprehensive master chronology. I think some people like to call it, and then you can truncate it.
Yes.
For a specific purpose. Now, if you can do that, great. But if you're computer literate, perhaps you know how to do that. I'm probably not one of those people. I can do my own sort of chronology, quite the bare basics. But if that functionality exists, then that's great. We're not trying to tell you to not to do or provide a more comprehensive document in those circumstances. But otherwise, I think the shorter the better. I think from my perspective.
And it just comes back to like understanding what's relevant.
Yeah.
And that comes back to looking at, again, what's admitted on the pleadings, what remains to be proved, and having an overview and an understanding of the case.
Are there any ethical considerations?
Oh, yes, there are. There are quite a few of those. For instance, under the bar rules, a barrister is not meant to invoke the powers of the court, to force someone to go into that process, unless there's some sort of basis to do it. In fact, there's a rule, bar rule 60, and it says a barrister must take care to ensure that the barrister's advice to invoke the coercive powers of a court is reasonably justified by the material then available to the barrister. So I guess the take-home message here is that when briefing a barrister, there really has to be some material available to commence a proceedings. And there's also, verification of pleadings as well. And when it comes to, settling pleadings and examining witnesses, it's the same thing. You have to have material available. For instance, you can't go and allege fraud if you don't have a basis for that, or other things. You can't just randomly attack someone. And it comes back to the responsible use of the privilege. So there's those considerations. And apart from what we can and can't do, there's also the barrister can return a brief under certain circumstances. And if you can't secure the attendance of the solicitor, of the clients, if you can't receive adequate instructions, then there is a right under Rule 105 F1 of the bar rules to return that brief. And the reasoning behind this is that you consider that it's really prejudicial to the client, or perhaps inconvenient for them not to have this occur. So, you're asked the question a few times, conference, document. If nothing's forthcoming, and the barrister becomes concerned about the case, ultimately they can return it. So that's sort of something to bear in mind as well.
Absolutely, and I suppose if you've been asking your instructing solicitors to provide you with those documents, and perhaps emails have been left unanswered, and it's been a significant period of time. It would have to be a significant period of time. It couldn't be sort of a week or two.
That's right.
But let's assume, for present purposes, that there's been a significant delay in between responding to requests, and perhaps court deadlines are looming whereby an amended statement of claim or something has to be filed, or an amended pleading. In those circumstances, a barrister might feel very anxious about whether or not he or she could actually discharge the professional obligations, and so therefore might return a brief accordingly.
That's right.
And it's something which sometimes is overlooked, especially when, as you say, there are allegations of fraud, or in perhaps defamation, malice and things like that being alleged, which is akin to fraud. And sometimes it's very thin, and you actually do have to really consider whether there's a proper basis for alleging that malice or fraud.
You do, and even submissions, there has to be some sort of evidentiary basis. And it's a very lonely task when you're asked to draft submissions and you're asking for evidence and there really isn't much of it. The court's not impressed with it either.
So let's move it on a little bit. So we've got the brief, and it's in tip-top form, and it's got a great index. It's actually in a folder. It's arrived neatly with a red ribbon around it.
It's paginated.
It's paginated, which is even better. You've gone through your brief, and you've got some queries, and perhaps you've got a few things that you've got to action prior to doing the work that you've been briefed to do. Post-brief conduct then, what's the sort of the next step, as it were, for you as a barrister?
Well, I think it's good just to read all that material, really look through it all. Start the chronology as I go along. So I'm reading documents, I'm putting things in. And no matter how well you prepare a brief, we're going to ask you for more documents, aren't we? There'll be something.
Yeah, well, sometimes, I mean, if you thought of a point and perhaps you just want your own anxiety placated.
Yes.
You might just want to see a document just to say, oh yeah, okay, well that's not that relevant, or you just never know. And so I think because we've both been probably in a situation where you've been in court and you don't think a document is going to be relevant, and then it drops on your desk at the bar table and you think, oh, actually, this is a bit more relevant than I thought. And so to avoid that pitfall, you might request some documents. But do you then, I suppose what I'm getting at is, do you then organise a conference? Do you get solicitors on the phone? What's the next step for you?
Yes, after I've looked at things, I do like to have a conference, and I like to see witnesses early on as well, to form those impressions. Like I said before, to see whether or not we need to rely on them. And this is a way of working out what evidence might be deficient, or what needs to be looked at first, what we might need from the other side, just to start thinking about all those things, examination of witnesses. Because sometimes, you have to resort to getting evidence from the other side's witnesses.
And I suppose it's sometimes necessary as well just to update the brief from time to time. And it's not unusual for there to be a bit of a time lag sometimes between the original brief arriving, perhaps an initial flurry of emailing and initial advice and that kind of thing, to then sort of later on, a month or so later, being asked to do something else, but there might be intervening events which you should really be told what they are.
Yes.
And so the best way of dealing with that, for me anyway, is either sort of frequent communications with the solicitor and then bringing everyone in for a conference. Usually that flushes out a couple of those events and salient information that we need to know, but also. It might assist with the advice work that you might be asked to draft.
Yes, and things do develop and evolve. So again, thinking about prospects and where the matter's up to is an ongoing process. I think managing client expectations as well, having conferences and seeking these things is helpful for everyone to know what's happening.
And it's really helpful sometimes for. I found anyway that when you've been briefed in a long-running matter, and there are some times that it's not unusual that the briefs need to be updated to such an extent that someone from the law firm has to come physically to your chambers and take out large swathes of documents and then replace it with other documents. And so it's important that it just keeps the brief alive, I suppose, as opposed to being a stale brief. It's got to be an alive and kicking brief.
Yes, I think that's where it really helps to have organisation, and especially when there's different people in the team, to have the same brief, and then it can be updated and everyone can find where things are, because it can happen the other way, where you start messing with your own brief and you continue to do that and everyone's got their briefs organised in their own ways, but it does make it harder to work together as a team when it's not a coordinated effort.
Yeah, no, I totally agree with that. Just noticing the time, I think we've probably got about another 5 or so minutes. Is that right? I'm going to take that as a yes. Looking at how to lose a case. Now, I don't know why people have put me on this panel to talk about how to lose a case. But I've got some views on this, and I have to praise you this with, there's a fantastic article. If you haven't if you haven't read this article, there's a barrister who very, very sadly passed away, called Edmund King KC from Essex Court Chambers in London, who did a fantastic article on how to lose a case, and it's a very entertaining read. What we're probably about to discuss is very much taken from that article, perhaps with an Australian slant. But there are, I suppose, like five or six things to talk about. The size of the team, I think, is really important. Now, you come from Mallesons originally. That was your background. You had been well versed with working in big teams.
Yes.
I'm probably coming at it from a different angle because I went straight to the bar when I was back in Wales, and I've only ever worked with really sort of smaller teams. One or two cases I've had have over the years needed a bigger team, but predominantly it's been quite small. And I find, I don't know about you, but I find smaller teams can be very adept, and they very much gel together a lot quicker than a big team. And if you have a document which needs to be generated, it can be turned around really quickly with a smaller team. Whereas I'm going to assume somewhere like Mallesons, it's going to have to go up the chain quite a few times. It's a bit of a slow process unless you've really got to turn it around, and then someone junior is going to be working all the hours to get it done. But has that been your experience?
Yes, I mean, I think there's a number of different aspects of them. Of course, when you're working in a bigger team in a larger law firm, it can be, like I've said before, that you don't have perspective over the whole case, or that maybe you might not feel like as if that you have much to contribute to that, whatever's happening. So coordinating a big team is probably the responsibility more of a senior counsel trying to keep abreast of it, or the partner. But there are things that can be difficult, because in a smaller team, like you say, it depends on people's availability too. If you can all work together on it, that's great. But sometimes the teams are bigger because counsel are involved in a number of different cases at the same time. So it might just be that sometimes one person can do one thing and one person can do another thing. So there's a bit of divide and conquer. But the problem with that is that then maybe there's less oversight of all aspects. So there might be a number of different patents and people are responsible for different ones, but then they also interact with each other in the end. So yeah, it's more complicated to keep a track of all of that in a bigger team, but sometimes there's not much avoiding it given people's availabilities and the sheer number of documents and issues.
But I suppose if you're working in a big team, you've really got to sort of gel together and trust each other, which sort of leads into that second aspect of things, I suppose, is having a team that actually works well.
Yeah, sure.
And if you don't have that, and there's a bit of distrust there, perhaps it starts to fragment. And it's very easy to lose a case from that, because it's not really coming from a really good sort of structural sound based, I suppose.
And I know there might be that. I mean, I think patent cases are usually quite civilised, so I haven't really experienced that in those cases, but I can imagine there could be, other cases that are big and go off the rails in that way. But in my experience, it's been civilised.
Yeah, well, I've been very lucky in the way I've been in cases like you, which have, despite being in defamation, have been quite civil. But I suppose the other thing to think about is a bundle that isn't, or a court doc. I still use the English language of bundles as opposed to court books, but court books that are badly prepared, for example, I think is another surefire way of getting judges offside. Judges aren't going to be doing favours as a result, as curious as that might sound, but they're not going to be sort of bending over backwards to help you out.
No, it's a strange thing, but the page on which something is on, the ability to say this volume, this folder, divider, this page number, we need to know that, especially lots of documents. This is too hard you can't look through documents in court without page numbers. And sometimes I get things last minute, and I just get a copy and I put all the numbers on it myself. I put it on for the judge for myself, and I use that because it's essential.
Yeah. It's absolutely critical. I remember as a junior lawyer, I remember when I first started off having to write, in pencil the going through the pagination of a document. And I used to hate it. I just think, why am I doing this? This is what I've done, gone to law school for, etc. But it's actually one of the most critical things you can possibly do.
There you go, important.
It is very important. And I think the usability factor as well is really important. For me, some top tips, I think, which you can give to some junior practitioners, those online who are watching, even with a court bundle, as practical as this is, no one ever does it. If you have the index and a brief index on the inside cover of the folder, so when the barrister, who's obviously antiquated because they're not on an e-brief, is addressing the court, you know exactly where everything is on that index very quickly by just lifting up the papers. And there are some times I do that myself because no one else does it at all. Everyone in Australia, I don't think.
It's a good idea.
I don't know why people don't do that.
We do now.
Well, hopefully people will now do that. And I suppose to the extent that it is an e-brief, the usability factor as well is also really important. Even still, make sure that the thing works, and so have a dry run, making sure that everything is where you think it should be, and consider, I suppose, the screens and how it's going to be seen by those in court.
You do need to have a trial run, because I downloaded a court book for this case I was on last year, and I couldn't write on it. And then I realised I had some sort of wrong version, or there were two versions sent around. So you've got to test it. And then, I mean, that index is very long, but I printed off an index as well, so I could sort of try to work out where these were, and you learn. But
yeah, and is it one of the answers to this with respect to indexes and court preparation or court book preparation? Actually getting senior partners, senior lawyers involved in the preparation process, including barristers, because it's so important, and so frequently do certainly smaller law firms perhaps just give that work to junior lawyers who then take ownership of it, who are perhaps inexperienced, and are acting again out of anxiety and trying to include more than they have to. But having sort of senior input will actually sort of...
That's right, into the index and its structure, because ultimately the person who's presenting this in court and the person who has got to do the examining needs to be able to locate that information. It's about locating information quickly. And so really the person who's going to be speaking should, I think, ideally for themselves, have input into that, so that you can react to things in court and find documents. And then, whether senior and junior counsel, the junior counsel should always be working out what documents have been spoken about, locating that, so they can shove it across in paper, electronic, or any kind of form, if their leader is distracted or looking something else or dealing with several issues at once. Yes, so being across the documents is really important.
Now, noticing the time, just one more point I was going to make with respect to how to lose a case, and that's to not fail to do witness preparation.
Yes.
And that's really from the bare basics. Now, you might have a really well-versed witness who's been to court many times, and this is going to be less relevant. More often than not, though, you're dealing with lay people that haven't gone to court on a regular basis, if at all. And what I was going to say, if you haven't already seen this document, it's fantastic. It's a document which was prepared, I think, when His Honour Justice Lingren was at the bar, so it's quite some time ago. But it's how to prep your witness prior to them giving evidence, and it goes through the stages of, this is what a courtroom is, this is where the judge sits, this is where the barristers sit, all the way through to this is how you answer cross-examination, or this is how you will give your evidence in chief. Something as basic as that can be a really useful document, and I've seen that play out myself, where in most cases that I'm involved in, depends on the situation, but most of the cases I'm in, I'll give lay witnesses, even government witnesses, that document, and it's amazing how much it just calms them down, even though it's quite old, and also nothing much has changed, by the way, insofar as like answering examination and chief cross-examination, and it gives them, it arms them with that knowledge, and then you can go through it with them in person, which can, I think, help a great deal. And failing to do that kind of preparation, even the most basic preparation, can lead to a witness unravelling in the witness box and forgetting their name, as happened.
This is such an unfamiliar setting for some people. So I think even looking at the courtroom, being familiar with it, all of these different aspects are going to help a witness. And sometimes I explain to, you're giving your answers to the judge, really. And there can be difficult cross-examinations sometimes unfairly so. And if a witness can deal with that themselves, even though a barrister might have to intervene, or the judge, but if a witness can, deal with that, it's good for their evidence as well.
Now, on that note, if there are any questions that anyone here would like to ask, now's your time. If there's anyone online, perhaps Jackie might be able to tell us if there's someone online with any questions. If you do have any questions, please feel free to ask them now.
I have a question.
Sure.
So, as I'm sure everyone knows, there's the new AI practice note in the New South Wales courts, and also in other courts as well, just not the federal court yet. But there's quite strict requirements in relation to both open and closed source AI, and obviously there's the exception to affidavits. But as barristers, how proactive would you like your solicitors to be in terms of whether AI has been used in preparation of things like chronologies, just any documents, discovery, things like that?
I've got a view on that, if you have. For me, if it's a document which is going to be used and discharged in court, I'd want to know about it. And I'd want to be involved in the process of settling that document, even if AI has perhaps been involved in the creation at a very basic level. I feel uncomfortable about those sorts of documents currently going before the court without me having seen it. And I think most barristers would say the same in a lot of the practice note in the Supreme Court. If it's a document which has been generated purely for internal purposes, I still want to be told about it because that would affect the level of trust I have in it if it's a particularly important document, even for internal purposes. And like Josephine was saying earlier on, if it's a chronology, for example, it would have to have the source attached to the event that's the subject of the chronology. So I think it would be important, from my perspective anyway, to be told that AI has generated that document. And I would have assumed that solicitors, whether it be a partner or a junior lawyer, has double-checked the source references, and it would be a particularly frustrating process if I was going to the source documents and it just didn't match up, for example. But certainly with respect to anything being filed in court or being discharged in court, if we're tendering something, for example, I'd want to know about it because we'd want to make sure that we've complied with the practice note in the Supreme Court, and I think the federal court's not going to be far behind.
Yeah. Thank you.
Yeah, I think so, particularly so in relation to the evidence of witnesses, because it's meant to be their evidence, not being coached or anything. So I think there's, and ideally, in an ideal world, in their sort of language as well, which an AI is not going to replicate. And there's also issues as to confidentiality and so forth, because, you share that and then it goes into the general data set potentially. So there's client confidentiality issues. So I'd be particularly... And that I guess is why there's the practice note there dealing with the statement in witness statements. I would just prefer not to have it there at all when it comes to witness statements.
No, I agree. But it's a good question, though. Anyone else? Yeah.
First of all, let me just say thank you very much. That was very useful. I don't know if this is quite in the scope of the seminar, but what would make in your opinion, a good instructing solicitor? What makes a good instructing solicitor?
Could probably have a whole seminar on that. Do you want to take that one?
Look, I think somebody who is diligent, who works, who reads documents, who will look up the law and have a considered opinion, who communicates with you, who provides documents. I think someone who's diligent and competent who's across the facts of the case and the law generally, and who can be, you know, honest about what they know or don't know or need help with or don't.
Yeah, no, I agree. I think someone who makes life easy, or at least tries to make life easy. Aside from my more sophisticated clients, you know, I'm very lucky in that I work with a lot of very, very competent in-house lawyers. Sometimes I'll work with smaller firms and even larger firms who are a bit more hands-off. And you know, documents aren't where they say they are, and it's up to you to, you know, what do you think? I want there to be some sort of discourse between solicitor and barrister, so we come together as a team, and it kind of makes my life easier, I suppose, to come to, if there's a hard decision that has to be made, then I like to do being informed as much as possible by someone who's proactive and not just someone who's hands off, I suppose. But generally speaking, and truncating it for the purposes of tonight, someone who makes life easy, I think, is the short answer.
That's great, thank you.
Do we have anything online? Then I think we can wrap it up. Thank you very much for attending. And if anyone does have any questions, please feel free to email them through.